Who will pay my debts after I die? There's a recent Fox Business article, and according to that article, Americans are dying with an average of $62,000 in debt. And certainly the question arises, what happens to that debt after you die? Well, what's going to happen with that debt after you die primarily depends upon a number of things. It's going to depend upon what kind of debt it is, whether there's a cosigner on the debt, the size of the estate, and in many cases, if the debt is secured or if it's unsecured. But first, let's start with an understanding who is not responsible for paying your debt. And it inevitably happens. A spouse dies. Oftentimes during the first meeting with the surviving spouse, we'll be reviewing the assets, we're reviewing the debts, and the surviving spouse wants to know, do I have to pay my spouse's debts that are not my debts? Do I have to use my money to pay those debts? And in general, the answer is going to be no. Under Michigan law, a spouse does not have the legal obligation to use their assets to pay a deceased spouse's debts. We had a client, this goes back several years ago, fairly tragic situation, young couple, had gotten married. Husband had borrowed in the neighborhood of $20,000 or $30,000, this goes back a lot of years ago, on credit cards to pay for different aspects of the wedding, the honeymoon, etc. And he died while they were on the honeymoon. Question that was asked to us by the surviving spouse: did she have to use her money to pay off her now deceased spouse's credit cards? And the answer was no. Similarly, children, just because they are children, do not have a legal obligation to pay the debts of their parents. So when you die, if you have debt, your children are not obligated to use their money to pay your debt. So start with that understanding. Spouses are not responsible for their spouse's debts. Children are not responsible for their parents' debts. Now let's look at different kinds of debts, though, and talk about those a little bit more particular. Unsecured debt. Unsecured debt, for example, credit cards. Credit cards, we all know what they are. Most of us have them. That's considered an unsecured debt. If it never gets paid, they can't sell your house or sell your car or do anything like that to pay it. Again, individuals who have their own individual credit card and have debt on their credit card when they die. That's what we're now talking about. You can also, though, have joint credit cards. You're going to have to look at joint credit cards differently because joint credit cards create joint obligations. So if you and your spouse have a joint credit card and one of you dies, that is now a debt that continues to be the responsibility of the surviving joint credit card owner. It's not because you're married, but it's because you had a joint credit card with your spouse. Another kind of unsecured debt, personal loans. Somebody has loaned you some money and it's not secured. There's simply a promissory note of some sort. And another one that oftentimes arises in settling estate are outstanding utility bills. Outstanding utility bills or perhaps outstanding taxes that are due, or in particular property taxes that are going to be due. Those will be all types of debt, although the property tax, while it's not technically a secured debt, it is treated as a secured debt because if the property tax doesn't get paid, then the taxing authority has a right to sell the property to pay their taxes. But generally speaking, set aside the property taxes, which is a unique situation. Credit card debts, personal loans, those types of unsecured debts. When you die, your estate is responsible for paying those debts. If you do not have an estate, if you don't own anything at the time of your death, then those debts will not get paid. It happens oftentimes. We'll have somebody come in where there's really no estate to be probated, but perhaps a person had significant credit card debt. Had one of those recently. Gentleman had used his credit card, bought a very nice diamond ring for his girlfriend. To anyone's knowledge, he hadn't been sick, but he had a heart attack. He died before he paid the credit card off. He didn't have anything in his estate. He owned nothing else. Well, in that case, credit card company eats the loss. It's one of the reasons credit card companies will tell you that they have to charge us the fairly exorbitant rates that they do for the pleasure of using a credit card. But generally speaking, unsecured debt, it's the obligation of your estate to pay unsecured debts. And if there is no estate, then there's not going to be any payment made on that unsecured debt. Secured debt, real estate mortgages, car loans, and again, I guess a kind of a type of secured debt, if you think about it, would be property taxes. All of those things have to be paid, or the asset that is used to secure them will have to be sold to pay them. So your mortgage that you have on your home doesn't go away just because you died, or your loan that you have on your car doesn't go away just because you died, or the property taxes that you owe on your home don't go away just because you died. If they don't get paid either by your estate or by somebody else, then the debt owner, in that case, the mortgage company, would have the right to sell the house to pay the mortgage. Car loan company would have the right to repossess the car. Taxing authority would have the right to foreclose on the property, have a tax sale, if you would, on the property. So those debts will have to be paid out of those assets. Now, again, if you look at last week's episode where you owe more money on your home than your home is worth, the bank is still going to foreclose on it. It's simply a question of whether or not the bank is going to be able to come after your estate for any excess amount. But as far as the secured debts are concerned, those are going to have to be paid, or assets are going to be repossessed or sold, foreclosed on, etc. So let's talk about creditors now. Those are the people that you owed the money to. They have a claim against your estate. Go back and look at those credit cards. You die, you have credit card debt. The creditor has a claim against your estate, which basically means your probate estate. Any assets that you owned that are going to now go through probate, part of the probate process is identifying debts, determining what are legitimate debts, making arrangements to pay those debts, and all of that gets done before assets get distributed out of the estate. There's an order of priority under the probate law by which it is determined what gets paid first. And essentially what gets paid first are funeral and burial. Next is going to be the cost of administrating the estate. After that is going to be your debts. Now, secured is going to get paid first because those assets otherwise will have to be sold, and then unsecured debts. But they get paid out of assets that go through your probate estate. Again, if you have no probate estate, then there are no assets available to pay those unsecured debts. Well, what about if you have a living trust? People say, well, I have a living trust. Can a creditor go after my living trust? Generally speaking, yes. Generally speaking, the living trust is going to be liable for any debts that your estate doesn't cover. So if there aren't enough assets inside your probate estate, a creditor could look to your living trust to pay those assets. Again, those get paid before the distributions come out of your living trust. So if you thought about all of that, what I just said, credit card company going after your probate estate or going after the assets that are in the living trust to get paid, if there are no assets to be probated, if there are no assets in the living trust, and we have those cases sometimes. Maybe when the trust was created, there were substantial assets. They've all been spent, used up. There's nothing left in the living trust. In that case, creditor is not going to get paid. Now, there's another piece that has to be factored in when we look at settling the estate, and that is this. There's a process, when we look at probate in particular, there's a process by which a creditor has to submit a claim to get paid. And normally part of the probate process is, quite frankly, forcing creditors to submit their claims. And then if a claim is denied by the personal representative, it now becomes incumbent upon the creditor to file a lawsuit if they want to get paid. So there are processes, even within probate itself, that sometimes discourages creditors from actually pursuing a debt because sometimes they simply decide that the debt is not worth all the hassle that's involved. What about assets with beneficiary designations? Assets with beneficiary designations pass out of probate, and if they have an individual as a beneficiary designation, they pass out of your trust too. So life insurance, as an example. Normie has a beneficiary on your life insurance policy. Well, that life insurance money goes right to the beneficiary, doesn't become part of your probate estate, doesn't become part of your trust, therefore not subject to claims that would be presented against the probate estate and the living trust because there are no assets inside those probate estates or the living trust. That's when creditors make claim against your estate. What about if you have a cosigner on a loan or you are a cosigner on a loan? Well, unfortunately, a cosigner on a loan generally remains 100% responsible for the debt. So if you've co-signed a loan with somebody and that somebody dies, your responsibility did not go away. That's why if you're going to co-sign a loan with somebody, you might consider, certainly if it's enough, you might consider requiring them to buy a life insurance policy that'll be paid out to you in case they die. That way, you would in fact have the money to do that. A lot of parents on student loans that co-sign student loans with their children, what they should think about is requiring the child, even if the parent's going to pay for it sometimes, to get a life insurance policy that would be paid out in the event that your child dies, so that if the child dies and you're still on the hook for the co-signed loan, at least you have the cash available to pay it. Now, there are some exceptions. As I understand it, Parent Plus loans, which are a type of student college education loan, those parents are not going to be responsible upon the death of the child. Some private student loans are set up so that if the child dies, there's no obligation continuing on the debt of the student loan. And some of the federal student loans that are out there, you may well find that if the student dies, the loan is forgiven. So there can be some exceptions, but in general, if you're going to be co-signing a loan, it's incumbent upon you to know and to understand what is going to happen if your person that you're signing the loan with dies. What are going to be your obligations? So we have unsecured debts, we have secured debts that are going to be paid, we have the process for creditors to make claims against your estate. We can talk about co-signers. There's a whole nother category, and it's not really a loan, but it is a debt, if you will, that can be required to be paid out of your state after you die, and that's under Michigan's Medicaid recovery law. And I've had previous episodes of this program where I've talked about the 5-year look-back period. I've talked about the government, whether or not they're going to sell your house after you die. But under Michigan's Medicaid recovery law, essentially the federal government requires the state of Michigan to try to recover from your estate after you die the amount of Medicaid benefits that were paid. Not Medicare. We're talking about Medicaid, which is generally paying for long-term nursing home care. So there is a process in Michigan where Michigan Department of Health and Human Services is going to try and collect from your estate after you die the amount that was paid for Medicaid. So when they pay the money for Medicaid, they don't tell you it's a debt, but they treat it as a debt after you die. Now, the state can only go after assets that go through probate. So again, if you don't have assets that are going through probate, there's nothing for the estate to go for the state of Michigan to go after to pay themselves back. The main asset that you can have and qualify for Medicaid is your home. So you want to make sure that your home is set up so it does not go through probate. And I've had previous episodes about the program where we talk about that in much more detail. It also doesn't apply to everyone. There are certain exceptions of the Medicaid estate recovery law, but I'm not going to go through all those particular exceptions for purposes of today's discussion, but there are exceptions where the state is not going to be able to go after your home to get paid back. Understand, though, it is a debt. It has to be considered. When you die, your personal representative, your family member is going to be receiving one of those letters, or your spouse receiving one of those letters from DHS wanting information about the estate so that they can submit a claim. Now, let's assume that there are no assets to pay the debts. Nothing's going through probate. Nothing's going through a trust. There are no assets available to pay the debts. And those letters keep coming from the credit card companies about wanting to get paid. Well, even though the credit card company knows it cannot collect from you, they're often pretty good about trying to guilt family members into paying the credit card. You can end up with endless phone calls from the credit card companies. What we normally tell people to do is, look, send them a copy of the death certificate, send them a letter that there's no probate estate, there are no assets to pay this creditor, and please don't contact us any further. Normally, that should stop them, but it doesn't always. Certain credit card companies are going to continue to call, and at some point you simply get to a position you're just going to be hanging up on them. All of this discussion about debts, think about it up front as part of your estate plan. For some clients, estate planning is also about minimizing payment of debts. We generally think of estate planning as what do you own and who's it going to go to. Another piece of the puzzle, the estate planning puzzle, for some clients, in fact, is going to be planning around debts and what's going to happen with those debts when they die. There's another planning option that I've talked about in previous episodes, and that's the use of a domestic asset protection trust. A domestic asset protection trust is a specific trust that can be used for certain clients when it makes sense as part of an estate plan to minimize payment of their debt. So who is going to pay your debts after you die is very much dependent upon what the nature of the debt is and what the nature of your estate is after the time of your death. Certainly it would behoove you, if you're settling an estate, talk to an attorney to make sure that you understand what the obligation are for settling, for paying debts, whether you're the trustee of a trust or personal representative. And as part of your estate planning process, it is a good idea if you have significant debts that you're concerned about, that those are going to be addressed during your preparation of your estate plan.